Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Jones Act or Longshore and Harbor Workers Compensation Act. The Jones Act protects injured seamen, offering legal recourse against employers and co-workers whose negligence causes injury during the course of employment on a vessel. Those claims made under the Jones Act can also potentially raise claims that a vessel was or is unseaworthy. In the event that a seaman dies, wrongful death may be claimed based on the Jones Act, on general maritime law, or on a separate federal statute, the Death on the High Seas Act. The Jones Act offers remedies to seamen injured during the course of work on a vessel. This federal act enhanced provision from the Federal Employers' Liability Act or FELA, a statute providing remedies for injured workers. As a result of the Jones Act, injured seamen may recover damage from their employer when the negligence of that employer or a co-worker causes injury. The Jones Act is specific in its application only to seamen, individuals with a vocational connection to and who contribute to the function or mission of a navigating vessel. Stated simply, the Jones Act covers those persons who do the ship's work. An individual whose work is covered by the Longshore and Harbor Workers Compensation Act may, in some cases, also be treated as a Jones Act seaman. A competent maritime attorney can figure out whether or not a particular individual is a seaman for purpose of the Jones Act. In some cases, the Jones Act may protect seamen even when they are not working on a vessel. Should the seaman be injured while temporarily working elsewhere, the Jones Act may still be applicable as long as the temporary assignment is in the service of the ship. Failure to provide a safe workplace may give rise to a claim under the Jones Act. If the vessel or another location under the employer's control is the unsafe place, unseaworthiness claim may be pursued under the Jones Act if the employer is also the owner of the vessel and if the injury was caused by an unsafe condition on the vessel. An employer may also be liable if an outstanding condition is a violation of a safety statute and that condition caused the injury. Finally, an employer may be liable for failure to provide medical care. Under the Jones Act, employers are liable not only for their own negligence, but also for the negligent behavior of other employees or individuals for which the employer is responsible. This most directly includes other employees, in example, an injured seaman's co-workers. Additionally, sometimes independent contractors may be viewed as the responsibility of the employer. An employer must attempt search and rescue for any overboard seaman as long as it's feasible that he or she may still be alive in the water. Failing to do this can result in liability under the Act. Under the Jones Act, employers owe their seamen a higher duty of care than in an ordinary negligence case. Due to this, employers may be liable if the breach of the duty, however small, in any way contributed to the seaman's injury. An employer's liability may be reduced in case in which a seaman contributed to his or her own injury. Even if the seaman willfully proceeded with a dangerous activity that resulted in injury, the compensation cannot be reduced under the Jones Act. Generally, a transact claim must be proved within 3 years of the injury. A qualified lawyer should advise on when and where it's best to file such a claim. The Longshore and Harbor Workers' Compensation Act is a comprehensive workers' compensation program for maritime workers injured in navigable waters. The law spans the legal gap between the Jones Act protecting seamen and state workers' compensation, protecting injured workers within a particular state but rarely on navigable water. This compensation system is administered by the Federal Department of Labor. Injured workers qualifying for coverage are legally entitled to disability benefits. Under the Longshore and Harbor Workers' Compensation Act, entitlement to benefit is not dependent on proving the employer at fault for workers' injuries. The Longshore and Harbor Workers' Compensation Act covers injuries occurring in the course of maritime employment. Maritime employment may include the loading or unloading of vessels, the repair and building of vessels. Navigable waters may be defined as places beyond those where a boat could float. In this definition, navigable water may also include places on land adjoining water. A worker injured on a pier, wharf, dry deck, or terminal can be compensated under the Act. Similarly, areas near a pier or wharf can also be included in navigable waters, such as areas for loading, unloading, repairing, or building vessels. The Longshore and Harbor Workers' Compensation Act provides disability and medical benefits as well as rehab services. Medical services must directly relate to the work-related injury or illness. Occupational disease arising naturally out of maritime employment may also be included. An employee injured on the job has only 30 days to give notice of the injury. When an employee develops a work-related disabling condition or illness, notice must also be provided. A formal claim for benefits under the Longshore and Harbor Workers' Compensation Act must be filed within 1 year with the Department of Labor. An employer may formally dispute the claim or may begin payment voluntarily within 2 weeks or 14 days of the date of the accident. Should an employer dispute a claim, there exists a conciliation procedure to help the involved parties come to an agreement and resolve the dispute. If the parties are unable to resolve the problem, a hearing with an administrative law judge or ALG will be governed to render a decision. Finally, the Longshore and Harbor Workers' Compensation Act allows an injured worker to sue any person or entities or additionally to the employer believed to be at fault for his or her injuries. In order to pursue compensation for lost wages, you will have to properly calculate what you have lost and what you will lose in the future due to injury. This should include healthcare benefits, retirement matching, and other benefits you receive as a part of your employment. To calculate this number, you simply go back when you first had to leave work due to your injury. If you are paid hourly, calculate how many hours you would have worked if you had not been injured. Multiply that by your hourly rate and then add on the benefits you would have received on each missed paycheck. If you receive a salary, determine your weekly salary by dividing your annual income by. Multiply that number by how many weeks you have missed since your injury. It can be difficult to calculate lost wages if you receive unusual employment benefits or multiple financial benefits as part of your work. This is a good topic to bring up with your maritime injury attorney. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.